Hello, folks. This is our June 2024 Landlord Tenant webinar for covering the 2024 legislative recap. We're going to get started here in about a minute. I wanted to let everyone get in as we get going because we have a lot to cover today. And I want to make sure that we are able to get to everything. So lots of folks have registered. Thank you very much for being here. It's very exciting to be able to go over all of this. I'm watching as folks trickle in, as it were. This session is being recorded, as you heard when we started up, but just be aware that we will be putting this up on our website. I'll get into more of that in a minute. But again, we'll be getting started here in probably just about 30 seconds. Sorry, needed caffeine. There's a lot going on here today, so I want to make sure that I am awake and ready to go for it, as I'm sure everyone else is as well. All right, so I'm seeing that we are at 1:30 according to my clock. So I want to get started. Thank you all for coming today to our June of the 2024 webinar series on tenant landlord law. Today we'll be covering the 2024 legislative session recap. So we are going to be joined today by our policy director, Michael Dahl, as well as our policy attorney, Larry McDonough, and I will also be covering some of our things, some of the new laws and things that have come into play here. So let me get started with the housekeeping things like normal. This is going to be recorded, so you know. The first and foremost, what is Homeline? In case you're new here, we had a lot of folks registering for today. Homeline is a nonprofit. We serve tenants across the state of Minnesota. We've been around since 1992, and we've been advising over 315,000 renter households since then. We offer our services in 4 languages: English, Somali, Hmong, and Spanish. And this is our hotline number. We also offer an email and attorney option if folks prefer that. A couple of quick things. We do have some upcoming webinars. So next month, we're going to be covering the eviction filing statistics, mostly from the last year. So that is always, it's going to be a little data heavy, but it's really interesting stuff. We will have folks from our office covering all of that. And then we're also going to be doing in August, the topic will be what to do if you're a tenant with a less than perfect background. If you are interested in scheduling your own training, contact us. We do that more than just these trainings. We do also, just because we are coming into the new session and the new season, I want to make sure that we actually offer some thank yous to the folks who are funding this series. So we want to acknowledge and thank the Family Housing Fund for supporting Homeline with the grant that makes this entire webinar series possible on these new tenant landlord laws. As well as our in-person and virtual trainings for groups. So just want to acknowledge that since we are covering these new laws today, I wanted to say thank you to the Family Housing Fund. And again, if you're an organization that would like your own training or is interested and has staff members or tenants, et cetera, who would benefit from this sort of training, you can request one in, I'll put a link up in the chat, or otherwise it's at the website here on this slide. We do tailor our presentations to the audience, and depending on the location, can do in person or virtual, like we're doing today. All right, so then moving on. This session, like I said, is being recorded. It's going to be available on our website along with the slides or the PDF version of the slides in a few days, as soon as we can get it around the cloud. So normally we do encourage and love questions. You can ask questions today, but again, we have a lot of content to get through. So I am not 100% certain that we are going to be actually able to get to questions today. We'll see what happens. So just that caveat right here at the beginning. Questions are always welcome, encouraged, but I don't know that we'll be able to get to them in the time allotted by 3 o'clock today, just because there is a lot of content to get through. We are going to be applying for 1.5 standard CLE credit. So if you're an attorney here and you're looking for that, we'll be applying for those after this, and we'll send out an email with the code as soon as we get it. All right, and without further ado, I'm going to turn it over to our policy director, Michael Dahl. Michael, please take it away.
Thanks, Rachel. So to start things off with the conclusion is we had a banner year at the legislature regarding tenant rights. I could actually consider this year a continuation of what we saw as significant changes last year, that the biennium brought a number of changes and also many transformative changes to tenant landlord law. I believe we're going to be covering around 20 areas of law that changed during this past legislative session. That's going to be a lot of content for y'all to mull over and feel good about as happening at this past legislative session and the previous one. Um, Also, a number of changes were transformational in nature from this past legislative session. For example, mitigation of damages, which basically means that when a tenant has to move out before the end of a lease, that a landlord has to make at least some effort, a reasonable effort, to try to fill that apartment rather than just letting it wait throughout the terms of the lease. Transformational, and we'll get into some more details later. I also want to thank all of the organizations that played a key role in this year's successes. This year, many of the changes that happened were not a result of the things that Homeline worked directly on. There were a lot of organizations advocating at the Capitol for change, and to them, again, thank you. Next slide. Of course, you can't get everything. You can't get everything that you want. And so we did have some areas of bad news this year. As many of you know, for several years, advocates have been asking for a source of income protections, which basically mean that if a tenant has a subsidy of some sort, like a Section 8 or a Bridges subsidy, that they be able to use that, and a landlord can't deny them the ability to rent the apartment simply because of the way that they're paying their rent. That bill did not pass. It was one that was in play for much of the session, but again, it did not pass. We needed one more senator to support the effort, and we were unable to secure that vote by the end of session. And it was being talked about up until the last day of session. So advocacy groups were really pushing hard, as I'm sure community members were as well. Secondly, Homeline actually entered into this past legislative session with a 70-page bill, about a 70-page bill, where we wanted to say if Minnesota wanted to be a tenant-friendly state, here are some things to consider, and there's a lot to consider. Many of the ideas actually coming from what other states already do. There were some that we specifically dreamt up, but there's a lot that we borrowed from other states. A few of those provisions you will be hearing about later in the presentation from Larry and Rachel, but we had scores of ideas put in there, so we just couldn't get to it. And so we hope to actually use that bill that we had proposed as an outline for what we can accomplish in the next several years, or however long it takes for us to get many of these changes put into state law. We will continue to push the proposals in future sessions, and also work with legislators to understand what it is we could do to make Minnesota more tenant friendly. So that's all that I have specifically until the end of this session, but I will sort of be jumping in on some of the comments that, based on what Larry and Rachel share. I wanted to again say, banner year. We should feel really proud of what we worked on, and as you can see, there's a lot on that list that are part of what it is we need to cover.
Yep.
I'll turn it
So
over to you, Rachel.
thank you. Yeah. So this is what we have to cover. As Michael said, there's a lot. Larry and I are going to be kind of bouncing back and forth a bit on covering these, just because both of us at some point need oxygen to breathe and water to drink to survive, right? So we'll be partnering on this. One thing I did want to note for folks, I know that Some of the things that you'll see in here, there's notations that might be odd. So if there's text that it's crossed out, that is old or existing text that is going to be removed. So example there. Otherwise, text that is underlined that you see in the upcoming slides, that is going to be new text that is being added. So that's going to be the new law. Any text that has no notation, that's existing, and it's not changing. So just keep that in mind going forward for that. So first thing we're going to do, there are some changes in additions to definitions that, Larry, if you can cover those, please.
Yeah, thanks, Rachel, and thanks, Michael. One note on source of income discrimination is there still is a ordinance in Minneapolis that is in effect that covers that. It's been challenged in litigation by a group of landlords, and while they had some initial victories in it, they've more recently been unsuccessful with it. It's pending before the Minnesota Supreme Court right now, but the ordinance is in effect right now. Okay, so I'll go through some of these definitions, and then these definitions apply to some of the slides that we'll get later. When you're looking at a slide like this, you'll see a couple different types of underlining here. There's the darker underlining at the bottom of this slide. That has to do with what Rachel just mentioned in terms of new language. The underlining at the top of the slide is essentially a hyperlink. And so whenever you get a copy of these slides, if you look at them on your computer and you click on one of the hyperlinks, it'll take you to some source material. So what I've done on my slides is I've not only replicated the language of the new laws, but I have, like you see the underlining under section 2, that would take you to the exact space in the new law that's covered on this slide. Okay, so the first two definitions have to do with tenant organizing, and we'll talk about that a little bit later when we get into the meat of some of these new laws. But tenant association means tenants, either two or more tenants from rental units that are owned by a landlord. And it can be incorporated or unincorporated, so it doesn't have to be a formal organization. And the purpose of the organization is pretty broad: to improve housing conditions, amenities, community life, or contractual position of member tenants. It's important to note that this definition does not require that the two tenants be in the same building. So these could be two tenants of landlords, different buildings, and they could form an association. Next slide, please. And this is a companion definition of tenant organizer, which means a tenant or another, meaning another person who assists residential tenants in establishing a tenant association. And the only caveat is it can't be an employer representative or a current prospective landlord or an agent of the landlord. So that's to keep this kind of separate from some sort of organization or association that a landlord would create. And these definitions support a new statute, 504B212, tenant right to organize, that we'll cover on slides 31 to 45. Next slide. This is a really important definitional change. So violation and these definitions are all in the definitions section, 504B.001. This definition of violation is a definition that's referenced in both the tenant remedies action and the rent escrow action, where tenants are seeking to get relief against the landlord for certain types of violations. And the current violations are essentially number 1, number 2, and number 5, although number 5 is currently called number 3. And what this change did is it changed number 2 and it added 3 and 4, and then it pushed what is existing number 3 off to number 5. And it may not seem like this is a big change, but when you look at number 2, the previous or the current definition is a violation of 504B161. Now it's a violation, and adds a violation of 504B171. And you know, I'm going to take a look at this when we're done, but I think there might be an error in the underlining and crossouts here. because my recollection is this expanded number 2 to include all of 504B. So when Rachel's talking, I will take a look and see if I'm correct on that. I believe I am. So this would be a really big change. It would allow tenants in rent escrow actions and tenant remedies actions to raise claims of violations of anything in 504B and not be limited to 504B 161 and 171. So again, I'll check on that, but I'm pretty sure I'm right and that this slide is wrong. And if that's the case, that's my problem because I created this slide. Number 3 is violation of discrimination laws. Number 4 is a violation of rights in public and subsidized housing. And we have effective dates in all these slides. Most of them are effective January 1, 2025, but there are a few that are different. Next slide, please. Okay, so I just kind of summarized what this did. It expanded claims in rent escrow cases and tenant remedies actions. But there is a problem in that we proposed this change, and we're glad that it was accepted. But we had proposed other changes, as Michael had mentioned, in 504B. And a couple of those changes were in the tenant remedies and rent escrow laws to reference this expansion of clauses going from 1, 2, and 3 to 1, 2, 3, 4, and 5. Those were not included in the new law. And so, so the tenant remedies action and rent escrow actions only refer to clauses 1, 2, and 3, not 4 and 5. So we'll hopefully can get that remedied with a technical amendment, but that's the state of this change at this point. Next slide. Okay, I still have another, there we go. Yep. So this slide is the definition of abandonment. And abandonment gets used in a couple different contexts in landlord-tenant law. Abandonment of a tenancy, that would be when a tenant leaves. Abandonment of personal property is when a tenant leaves, but leaves some personal property behind. So we wanted to distinguish those two concepts for the purposes of the mitigation of damages law that Michael mentioned earlier that we'll discuss when we get to slides 45 and 46.
All right, so that's the updates for the definitions. So this we kind of organize into stuff that happens before the tenancy. And so before tenancy happens, there are a couple new laws coming into play here. First one is a whole brand new law proposed through the University of Minnesota predominantly, 504B.153. And what this is doing is it's outlining a tenant's choices if new construction isn't complete in time for a pre-established lease start date. This was in response to a issue with, I believe it was the identity property it was called, where it wasn't open, construction delays made it so that it was not available for occupancy on the promised date. And so this is going to be effective on January 1st of 2025, as are most of the new laws that we're going to be talking about today. Here's the link to that specific section of the session law here. And we'll go through with the new laws, we'll have the new wording here, but so the subdivision defines what new construction is, as opposed to, what existing construction, things like that. And then what a landlord has to do if it cannot deliver occupancy. So basically it's a landlord, if they're told that they can't deliver on time, they either need to offer alternative housing that the landlord has available to them that's reasonably equivalent, or the landlord, if the landlord's not able to provide that, then they need to provide the tenant with a cost of rent, that reasonably equivalent cost of rent for having to rent a different place if the tenant needs to do that, and termination of the lease agreement and return it to the tenant of all the amounts paid, like a security deposit and things like that. And these are at the tenant's option. So these are the tenant's options for if the landlord cannot deliver. And then these are the basically if they want to terminate their lease, how they go about doing that. And so, and I think big here is if the new construction for the rental occupancy is not available for the tenant within 90 days, tenants are just allowed to terminate their lease if it's that long of a wait. So again, that's going to be effective on January 1st. Waiver, it's not allowed. And these are the remedies. So a violation of the section is going to be tenants can follow recovery under 504B.231, which that is going to be the same remedy as the damages for ouster, basically. So ouster is an old-fashioned term for kicking someone out or preventing them from being in the space that they're legally supposed to be allowed to be in. And so the damages are 1 month's rent, $1,000, or actual damages, whatever is greater, plus reasonable attorney's fees. And those are in addition to any other remedies that might be available.
If I could chime in, this was you'd mentioned this was an effort of the university, primarily of the University of Minnesota. I want to really recognize that there were some key students that played a role in the negotiations of this provision, in testifying at the legislature. A number of students testified, and then also University of Minnesota Student Legal Services was quite helpful in this area. So that's one of the, I'm not going to be able to name for each of these things who did the work, but where I know it where I know it, I'm going to try to share who took the lead role on some of these items. So thank you.
Yep. And Jonah, I see your question coming through. We are getting there. So next thing, another new law that's coming up. This is going to be 504B.117, and that's involving ITINs. Basically, it's very straightforward. A landlord has to allow the option for a prospective tenant to submit an ITIN as opposed to a social security number in their application. And it lays out very specifically how that language is supposed to be in the application form. Again, effective on January 1st, 2025.
And many thanks to Copal for putting this one into, again, it's a very huge change that is going to help a lot of folks. And so thanks to Copal for putting this forward and doing the work to get it passed.
Absolutely. All right. So then next up, bouncing over to Larry.
Yeah, so this is a change in a law related to application fees, and it adds a provision that a landlord may not deny a rental application based on any of the following: a pending eviction action, a court file that is not public, has been expunged or has been destroyed, or any eviction action that has not resulted in a rental recovery of the premises or order to vacate. So if we could go to the next slide. This was really a response to the Minnesota Supreme Court decision from last fall that invalidated a 2023 law that would make eviction action records private until entry of judgment. My read of that decision is that the Supreme Court was not opposed to the concept, but was opposed to the legislature making that decision rather than the court making the decision through its rulemaking process. So this new law, if we could go back to the last slide for a moment, is essentially a way to reach a similar result, because the whole idea of the law from last year was to really keep pending eviction cases kind of out of the process of landlords considering rental applications. So this is another way to deal with that. And this, again, like most of the laws, is effective January 1, 2025. We can go a couple slides down now. So and similarly in the area of eviction records, and this now goes to tenant screening agencies. There are a lot of landlords that get their information from tenant screening agencies, although some simply get it from the court's website. This is a big change because it makes tenant screening agencies, it requires them to verify their records no more than 24 hours prior to issuing a tenant screening report. And the reason why this is really important is that you can see the crossed out language is that a tenant screening agency right now only would have to delete a reference to a court file if it knew that the court file had been expunged. And so common practice would be for an advocate helping a tenant to get an expunged file to then write to all of the tenant screening agencies, of which there's several, and give them a copy of that. And then they would have that obligation to take that out of their records. Now the obligation is really on the tenant screening agency to make it self-aware of what's happened with court files rather than to sit back and wait to be contacted by tenants. So this should be a really big change. It will take the pressure off of tenants to contact all the tenant screening agencies when they get expungements. My practice probably still will be to send those expungement orders to them, but that's just me. Next slide. And this simply tells us that the effective date is January 1, 2025. And again, this will, I think, relieve tenants of having to notify tenant screening agencies, although I still think a good conservative practice is to notify them anyway. And this is another change in the tenant screening agencies area. And the big change here is summarized at the bottom of the slide. Is this slide, this law really was, this section of the laws was really to the protection of landlords and tenant screening agencies. And it's really been flipped around to be expressive about the types of damages and remedies that tenants have. It was really essentially a remedies limitation statute, and now it's really an express remedy statute. And so it provides for damages, reasonable attorney's fees when landlords or tenant screening agencies violate the various tenant screening laws, and also provides for attorney general enforcement.
I'd like to point out for the tenant, there's a number of things that the legislature, certain legislators did in reaction to the Supreme Court decision that we received last year that you were talking about regarding records and expungements. And so I have to thank legislators who took a leadership role on these issues. We certainly provided some help, but much of the initiative to addressing the Supreme Court issue was the legislature trying to find a way to answer this in a way that neither body was going to disagree with each other on this. So many thanks to our legislative allies.
Okay, so the next slide, you might wonder, why are we talking about something that's not in 504B? Well, because sometimes things outside of 504B actually apply to landlords and tenants. So this is an update to the deceptive trade practices statute. This is a set of statutes that we call consumer law. And the reason why we care about that in the landlord-tenant world is tenants are consumers of both a product, which would be the apartment, and the services, which includes the maintenance of the property and other types of actions, with the landlord being essentially a business. And so that's why consumer laws apply to landlords and tenants. This is essentially I guess what you'd call a junk fee law. It requires different types of businesses to be more transparent about what their fees are. Now, you might recall, if you've been to some of our earlier trainings, that we helped create a law last year that's specific to landlords and tenants that requires landlords to disclose all non-optional fees and lease agreements and advertisements, and it's got damages and attorney's fees in that. And so these could be viewed as being compatible with this new law here, adding injunctive relief, which means an order saying to a landlord, stop doing something that violates the law. But there's a little bit of a nit to this that we'll discuss in the next slide. Okay, so this next slide makes a reference to where this law does not apply. It doesn't apply to a business or business affiliate where the business or the affiliate is regulated by the Minnesota Public Utilities Commission. So you might be thinking, why do we care about that? Well, the reason we care about that, and we'll discuss this on slide 39, is the big change in laws related to landlords and utilities may mean that landlords are now regulated by the Public Utilities Commission when they use what's called sub-metering. And so it might mean that certain landlords are covered by the Deceptive Trade Practices Law and certain ones aren't. It's a little bit hard to figure that one out right now, but I'll talk about a little bit more when we talk about utilities a little ways down the way.
All right, I'm on mute. And yeah, one of the things I think also important to point out, like we saw on the agenda, there's a lot of things coming on, and it's coming from a lot of different places. We were, pulling these from a lot of different areas of, a lot of different bills, a lot of different committees and things. These were all kind of touching on tenant landlord law. So yeah, it was broad this year. So now we're going to move on to during the tenancy, things that are impacting while there is a tenancy, in place. So first off, this is residential tenants' right to seek police and emergency assistance. This is an existing statute that has been in the books for quite some time. It's 504B.205. And really the only update to this particular statute is that it's very specifically calling out that emergency calls for mental health or health crises are protected emergency calls. So emergency calls, like calling the police, have already been protected as a right that a tenant has to make those sorts of calls. And now it's very specifically saying mental health and health crises are also protected calls. It also says that any local ordinance that might have a rule requiring eviction or other penalties for too many, when tenants make too many emergency calls, it specifically says that mental health and health crises calls are exempt from any of those sorts of rules that may exist at the local level. So this was just a couple of very specific words added into an existing statute. Again, effective on 1/1/2025.
And Minnesota National Alliance for the Minnesota chapter of National Alliance on Mental Illness did the work on this. Minnesota NAMI, it's known more commonly by. And so hats off to them to addressing what has been, and maybe we actually want to talk a little bit about what this was in reaction to, because it was a serious matter that about mental health related information being shared. This calling out that the calls were allowable. We don't need to go back to the old case or the old information that I'm referring to, but this was a Minnesota NAMI edition.
Yeah, so very clearly expressly saying that these sorts of things are protected, and something that people shouldn't have fear of making these sorts of calls if they are having these experiences. Okay. Going on to a big one, the tenant right to organize. So this is a whole new statute, 504B.212. And it does a bunch of different things. So we're going to probably, do a quick overview of this. And I'm hoping that we will have an opportunity to be able to do actually a whole entire webinar on this issue or on this new statute later on this year. But what this does is it gives tenants the right to establish and operate tenant associations. So those definitions are things that Larry covered in previous slides, slides 11, 12, I believe it still are. And it lists protected organizing activities. So it's not limited to this list, but it's like an example of common organizing activities. Prohibits retaliation from landlords towards tenants who are doing these organizing activities. And it creates penalties for violations of the statute. All right, so again, this is effective on January 1st, 2025. And here is the new new language. So I didn't underline it because this was just several slides of just underlined text. So it got a little overwhelming. But this is, so these are, tenants have of a residential building have a right to establish and operate a tenant association. Here are some of the activities that are included as their right to be able to do, like distributing leaflets in common areas, individual units, contacting other tenants, convening a tenant association meetings, and then the this is again subdivision 1 continued. So this is a substantial new statute. So there's a lot of text in here. So there are carve outs for if it, like, say, for example, a tenant organizer who's not a residential tenant of the building can be accompanied by a residential building by a tenant who does reside in the building, for example. So those sorts of things are called out. It's a very thorough statute as well. Retaliation is prohibited, so they can't, landlords can't increase rent, decrease services, alter an existing rental agreement, or file legal action against a tenant for actions related to their organizing activities. All right, so, and again, these are some examples of prohibited actions by a landlord. So like the existing retaliation statute, the burden of proof if the alleged retaliatory action is within 90 days of the tenant engaging in these activities, then it's presumed retaliatory. That's just in line with the existing retaliation statute that it is currently in law. And then, so if there is a violation, the tenant's going to recover up to $1,000 per occurrence, and reasonable attorney's fees is what it calls out.
For this one, Homeline is part of a coalition called Equity in Place, and Equity in Place played a leadership role over the past couple of years, getting us to this point and the law being passed. It was a close effort, or it was an effort that was started in the previous legislative session. They couldn't quite make it to getting a hearing because there were so many bills that were being considered last year. But it was one of the first bills that were heard, this session, and managed to get it to cross the finish line with everything that Rachel just talked about. Thanks, Equity in Place.
Yep. So, all right. And again, effective on 1/1/2025. Moving on, so someone had been asked earlier about early renewal of lease changes. So there were some language changes. This again was one of the statutes that passed last year that went into effect, and 504B.144. Really, this is just trying to clarify some language. So the crossed out language is what was there last year, and there was some confusion about that. So it's really saying, like, look, you cannot require tenant landlords to renew a lease sooner than 6 months prior to the expiration of the current lease. So basically saying, if your current lease ends in December of 2024, you can't ask them to renew it before June of 2024, sort of deal. So this was really just some clarification languages of the intent of what the statute was supposed to be. Whoops, too far. So yeah, effective 1/1/2025. Late fees, Larry. I believe that is yours.
Yes, it is. So we currently have a late fee statute that limits late fees to 8% of rent that has not been paid. This was a change that dates back to, I think, 2010. There's been a little confusion over how that should be handled when a tenant pays a portion of the rent and receives a housing subsidy that covers the rest of the rent. So this simply clarifies that the 8% late fee is limited to the tenant share of the rent, not the total rent.
And this one's mine. So existing statute again, 504B.113. So basically what this is saying is that if a landlord charges a fee, like a pet fee for a standard pet. Then what they have to do is that in that they have to disclose that fees are prohibited, so they're not allowed to charge fees for service or emotional support animals. So if the tenant to enforce this, if there is a issue with it, the tenant has two things they have to do. So basically that the landlord didn't provide that disclosure, and that the tenant would have requested and would likely have received a reasonable accommodation if the disclosure had been there. So to do that, that's what the tenant has to do. This is, again, an update to an existing statute, 504B.113. This went into effect back in 2022, I believe, was when that law went into effect. But this update to landlord required disclosure is effective on 1/1/2025. Utilities. Q's a big one, and Larry, have fun.
Yeah, so this is a big one. And it had so much language to it that we decided not to replicate all that language here because it probably would have been another 10 slides. But you do have the link here to the law, and when you get a version of this, a PDF version of this, you can tap on that and it will take you there. So this was a really big change in utilities law. It involved repealing the current statute 504B.215 and replacing it with a new statute 504B.216. It was a process of a lot of negotiations with a lot of stakeholders, including it was principally put forth by the Legal Aid Association, which is called the Legal Services Advocacy Project, but there were a lot of other players involved with it. And so there's a lot of nuances in this, and so I'm just really going to give you more of an overview of it. It allows for submetering. So submetering is when a landlord is, well, currently, what landlords are allowed to do is to get a bill and apportion it among a number of tenants. And there are some requirements on how that apportionment is done. A lot of us have felt that those requirements were a little soft. And so what this new law does, it allows for submetering. That would mean a landlord could have utilities coming in through 1 meter for like 10 units, and then could create their own submetering system to meter tenants directly. And so this is a little bit like homeowners. When a homeowner gets their utility bill, they're getting a directly metered bill from a public utility. Okay, so this allows for submetering, but it requires then the landlord to be compliant with a number of the requirements that public utilities have to follow in terms of limiting fees. There's a prohibition on apportionment of bills for electricity, but it allows for apportionment for other utilities, but limits how that can be done. Requires landlords that are doing submetering to give tenants a notice of their rights, prohibits landlord disconnection of utility service to tenants. And this is we already have a law that does that, but where we were starting to run into the problem is where a landlord was using like a submetering company. We didn't have a law that necessarily prohibited that company from disconnecting service. There also are remedies for the Attorney General enforcement. This is effective January 25 for leases entered into or renewed on or after that date. So a lot of the effective dates we're discussing today land right on January 1, 2025, but there are some that only come into effect at some point after January 1, 2025, when a lease is started or renewed at that time after January 1, 2025. There also are some new statutes in the Public Utilities Chapter 216B that regulate in more specificity submetering, including placing landlords who submeter under the Public Utilities Commission regulation. So going back to that deceptive trade practices slide that we discussed earlier, that might mean that those landlords that submeter are not governed by that deceptive trade practices law, but that landlords who do not submeter would be governed by that law. And so I know this is a lot to cover. I would say for any landlord that is looking at apportionment or submetering. They really need to nose into this and get familiar with it. Any tenants that are in buildings or tenant advocates for tenants in buildings that have been doing either submetering or apportionment of utilities also need to get up to date on this. And I think there'll probably be some trainings, whether they're done by Homeline or other agencies like Legal Services Advocacy Project, to really get into this, because it has been a complicated area and now it's a more complicated area. But the complications are to the benefit of tenants.
Thank you for that, Larry. All right. We're going to go back to me quick. 504B.161, this is the covenants of landlords or licensors. This is one of the most used statutes probably in Chapter 504B, and there's just some additional language that's been added. So basically it clarifies, the changes clarify that the statute requirements apply to all common areas as well as individual, units, and also to ETRA situations, that's emergency tenant remedies action situations, and the extermination of insects, rodents, vermin, or other pests on the premises. So basically saying that the landlord covenants, the landlord promises that all the common areas are also kept in reasonable repair and fit for their intended use, and that the ETR situations, which were updated in last year's session, as well as extermination of insects and rodents, and that stuff also is the landlord's responsibility. It also says that the landlord has to meet maintenance requirements of applicable health and safety laws. That was language already there, but including ordinances regulating rental licensing. So it really adds in that. So none of this was new. All of these things were things that the landlord was arguably already responsible for, but it really just calls it out in plain language in the statute. So again, this is effective on 1/1/2025, this language, but again, this is language that was, these are things that already were landlord's responsibilities. Moving on to action for rental of condemned residential premises. So again, another existing statute, 504B.204. And this is just, again, adding in some clarifying language. So basically, a landlord is not allowed to accept rent or security deposit for residential rental properties from a tenant after the lease premises has been, and then it gives some listing. So most of this was already here. What's being added is if it's been ordered to be vacated due to violations of housing, health, or fire code or rental licensing ordinances, and by the applicable, and then adding in federal as well as state and local authorities. And then removing the carve out that if the tenancy commenced after the premises was condemned. So removing that restriction and then adding in the code, the different code levels. Or if the tenant has been ordered to be vacated pursuant to a government taking. So there are some examples. Columbia Heights does this often, honestly, where they will tell the tenant they have to leave because the building's been condemned or a license has been revoked, for example, because of habitability issues. And so what this statute is saying is that the landlord's not allowed to accept rent or a security deposit for a residential rental property if these situations, these habitability issue situations are coming into play. A violation of this section is also a violation of 504B.161. That was the statute we just talked about. That then will create a rent escrow potential legal remedy for tenants. And this section has language so that says that the section is going to be liberally construed for protection of tenants. So that's just an indicator to the courts that when they are reviewing this statute, that if there's any vagueness, that they should interpret it to give the best benefit to the tenant involved. Since again, this is effective 1/1/2025. All right.
And Rachel and Larry, this is actually one that was it in the policies that we brought forward, if I'm
Yep.
correct. So
this is one of ours.
Yep.
as was a lot of the 504B.161 language changes that we just talked about. All right, Larry, rent changes into rent escrow. Oh, nope, this one's still me. Sorry. Basically, this is just a I put this in here. That's not a huge deal, but 504B is just changing referenced from another statute 504B.331, which is being repealed, and replaces it with the 504B.332, which is the new summons and complaint statute. I just wanted to call this out because it's important to ensure that if you have documents or anything else that kind of refers to this in your rent escrow paperwork, that it gets changed and updated so that it accurately reflects the new statute numbers. That's all. So. And finally, Attorney General Enforcement. There is a new law, 504B.501. And what I put on the slide here is literally the entirety of the new statute language. It just says that the Attorney General has the authority under Section 8.31 to investigate and prosecute violations of this chapter. So it arguably, again, was always there, but it was kind of called out very specifically piecemeal throughout the chapter. And so now it's just being like, look, the whole thing very clearly clarifying the AG has the ability and the authority to investigate and prosecute violations of this entire chapter of law, of 504B. So again, effective on 1/1/2025. Okay, we're getting there. End of the tenancy. Like what happens ending the tenancy. So tenant abandonment of dwelling. This is another big one. And this one is going to be about if a tenant abandons a dwelling, a rental unit, mid-lease, the landlord has to make reasonable efforts to re-rent the place to mitigate the damages to the tenant. So this is a new law, 504B.154. It includes a no waiver clause, and this is the new definition from the definition section about abandonment. Again, this is effective on 1/1/2025. And here's the language for the new law. So basically, it just is that the landlord, if the tenant has to leave for whatever reason, they abandon the unit mid-lease. Normally, that the lease is just a contract, and so there are consequences to unilaterally breaking a contract. And so what this is saying is that landlord, you have to try and re-rent the place just through reasonable efforts, whatever that might be in the circumstances, to re-rent at the fair rental value. So once that unit is re-rented or the tenancy ends, then the tenant's not liable for any rent after that.
I will say that this is something that you have to have more than two hands to count the number of years that Homeline has worked on this proposal. Many other states already have duty to mitigate as part of a protection that they have to have. And so this year it happened, and I know it was huge to Representative Agbaje to get this thing to get passed into law. So we're very thankful for that.
Yeah. So this is another one of those Homeline statutory language ones, and again, often it's already something that landlords do. Makes most business sense often to try and rent a place if it's sitting there empty. So this is just putting into actual law something that has already been a best practice for many years. Domestic violence. So again, another one that is Larry's. I could just stop talking for a second. Sorry, I was just on a roll.
Yep, you can stop, take a breath. So the domestic violence laws were proposed by the Association of Legal Aid Offices called the Legal Services Advocacy Project. And some of this is technical and clarification, but some of it is expansion. So we have laws in Minnesota that allow a tenant who's had to deal with domestic violence to terminate their tenancy. And so the first change on this slide is it focuses on a date that the tenant has to give a notice. And the notice previously or up to this point would have to say when the tenant will vacate. And sometimes tenants don't know for sure when they're going to vacate. And so what this now says is the tenant has to give a date on which the lease will terminate, and the tenant can choose that date, but then allows them, as we'll see in the next slide, to vacate before that date if they want. So let's go to the next slide. And so this slide, maybe it's another one after that, but let's just stay on this slide. So this slide the change here is to provide for other types of communication with a notice that's being given here. So that the tenant, I mean, part of the problem in landlord-tenant law and with a lot of laws is they haven't really kept up with digital communication. And so there are all kinds of laws in landlord-tenant, but in other areas that talk about doing something in writing. And a lot of people these days would think, well, okay, well, that could be a text message. It could be a number of different ways. And there isn't an overall change in the law that has really recognized that. And that's a place where I think all of the laws, not just landlord-tenant, could really be modernized to conform with how people communicate these days. So what this does is it allows the tenant to communicate by one of those means rather than just having it to be an old-fashioned letter. Okay. This also says that the set of laws here allows the tenant to vacate before a termination date. So the tenant can be saying, okay, I am a victim of domestic violence, and here we are on the 12th of June. I want the lease to terminate either at the end of this month or I want to terminate at some other date, but then I have that ability to vacate now if I need to. Now, the effective date on this is that it's 30 days following the date of final enactment. The final enactment, it was signed by the governor on May 24 of this year. So that means it's effective June 23 of 24. So it's coming up pretty fast. And I'll clarify this on the slide before we give you the PDFs on it. So that you don't have to investigate and do that math on your own. So again, what this does is it replaces vacate date with termination date. It expands the method of notice and allows a vacate date before termination date. Next slide. This adds that a landlord who violates the landlord's obligations under the domestic violence statute is liable to the tenant for statutory damages of $2,000 plus reasonable attorney's fees. We were trying to champion doing things like this to a lot of laws in 504B. There are a number of laws in 504B that have obligations and rights, but they don't have ramifications. And some of those ramifications became law, but a lot of them didn't. And that's one of the things we'll be looking at in the future is to try to make consequences more obvious for both landlords and tenants when they do violate the law. Now, this one is effective August 1, 2024. So again, what we just talked about earlier is effective June 23 of 2024. It's a little too bad that they're not lined up on the same date, but they're just not lined up on the same date. Next slide. Okay, this is, again, I think more of a technical change here, replacing the word forfeit with relinquish. To be honest, I'm not sure why this change was needed, but the point here is that if the tenant is exercising rights under this law and moving out, that they are then saying they're not going to do a claim for a security deposit. So again, I see this as kind of a minor change myself. Next slide. Okay, what this says here, I'm just going to move a little something out of the way here so I can see the slide a little bit better. Okay, so this makes it clear that if there are multiple tenants and a tenant is exercising their right to terminate the lease here, that termination applies to the other tenants as well. and the relinquishment of rights upon the end of this tenancy applies to other tenants as well. And then there's a express prohibition on a landlord commencing an eviction action against a tenant who has terminated a lease if the tenant has complied with this law. I think there have been some cases where the landlord is aware that the tenant's terminating the lease, but files an eviction case anyway. This one also is effective 30 days from the date of final enactment, which means that effective June 23, 2024. Next slide. Okay, the change here was really to deal with the fact that, and became much more obvious during the height of the pandemic, was that people could be getting services remotely rather than in person. And one of the qualifiers of terminating the lease for domestic violence is that the tenant has received services from basically domestic violence services. And the law as currently written required that to be in person. And so this change allows that to be remote. So it could be over the phone, it could be Zoom, any other way in addition to in person. Next slide. And this is more language that is there's a statement form that one of these qualified third parties can do, and that this change in the statement form is consistent with what we just discussed. And again, this would be effective June 23, 2024. Next slide. Okay, this is similar to a couple slides ago. This is in a different statute in 504B. This is the eviction grounds statute or eviction bases statute. And this is consistent with what we just discussed, where a landlord cannot commence an eviction action for a tenant who's terminated tenancy under what we just discussed. And also this would be effective June 23, 2024. Now it does, just back to that slide for a second. Now, if the tenant does give that notice, but fails to vacate, the landlord could evict for failing to vacate. Okay, and then there are also some remedies here for a landlord who's violating both this part of 504B 285, but also what we just discussed in 504B 206. Okay, now I'm done with this slide.
All right. I'm going to give Larry a brief, like 1-slide break while I talk about a very small change with a potentially big impact for lease termination upon infirmity. So this was another one of those statutes that was passed last year, 504B.266. And basically what it's doing is it's changing from if there's more than one tenant, it's taking out the all, and it's just saying that if one of the tenants instead of all of the tenants have a medical issue that needs to end the lease on, then they can end the lease for everybody. So if one of the tenants that's on the lease needs to go to a medical facility due to infirmity, then that is something that can terminate the lease for all the leaseholders if that's what is wanted. That's effective on 1/1/2025. So that is something where this wasn't one of ours. Michael, I don't know who championed this. I don't know if it was Rep. Her or.
Yep. A couple things I want to point out about this one is that if you are a constituent of a legislator and you think something needs to change, contacting your legislator is very important, because Representative Her heard from one of her constituents about this issue, that there wasn't enough money because the person who was paying most of the rent had to go to a medical facility, and so the ability to keep paying for the unit was not possible. And so a shout out to whoever that constituent was, and also Representative Herr, who called me at one point and said, "Michael, we didn't take care of this, did we?" And I said, "No, we didn't." And she said, "Well, are you supportive of doing this?" And it sounded like a good idea to us. So, well, I'm going to be thanking a handful plus one of legislators at the end of this session. Representative Herr definitely deserves kudos here.
Yep. So this will, yeah. So small word change, but big impact potentially. All right, we're going to move on to evictions and expungements. This got its own section because there is a lot of changes here, and so Larry is going to guide us through those.
Okay, I'm back. You thought you were going to have a longer break from me, but then again, you don't. So deal with it. Okay, so first we'll talk about expungement. Couple of changes here. Some of this is clarification and some of this is expansion. So the clarification here is if you go down to the bottom of the slide, number 3, it expands, in my view, kind of clarifies that if a case is dismissed by a plaintiff or a court or by the parties, that is grounds for mandatory expungement. And then go over to the next slide. And if this is going back to the domestic violence changes that we discussed, it's mandatory expungement if the eviction has been filed when a tenant has given the domestic violence notice and the landlord has violated that section. And so and then I've got really a summary of what I just said at the bottom of the slide. So let's keep moving. Okay, now this is, in my view, a clarification. It's kind of, the language may look a little funky to look at it, but essentially what it's doing is it's clarifying the effective date of the expungement law that was passed last year. And that clarification means that the mandatory expungement grounds that were passed last year that have been modified just a little bit this year apply to all eviction actions regardless of when the cases were filed. Now, I frankly think that the effective date from last year meant that, but there had been some pushback that those changes would only apply to new cases, and that was never our intention. We worked on that law last year. So hopefully this will clarify it, that if you have a case from 4 years ago and it was dismissed, that it ought to be expunged one, because it's older than 3 years, and also that it was dismissed. So hopefully this will clear up what has been in confusion in the minds of some people, but not me. Okay, next slide.
Larry, if I can
Yep.
ask you, this is actually going to impact not just tens of thousands, but probably we're going back in time and getting expungements cleared through this for tens of thousands, if not more, tenants. And I think we need to call that out, that it's a serious, well, it's something that you and we all assumed was the case last year. It's important to point out that now making this real for everybody, we hope, it's going to have a dramatic impact.
Yep, and hopefully, and we'll still have to see how this plays out. So this is a change that's effective now, because essentially it's changed the effective date of the law from last year, or changes the language surrounding it. Now, in my view, what ought to be happening is a lot of the mandatory clauses in 484-014 do not require the tenant to do anything. They're just supposed to happen, okay? And so the question now is the court going to do that? Court's going to do that automatically without tenants having to ask for it. Like if there's an eviction case, in my view, from 4 years old that was dismissed, it ought to be expunged by the court without the tenant having to go to the court and say, this ought to be expunged because it's older than 3 years and that it was dismissed. We've had some pushback from the courts on that from what was passed last year. Hopefully this is clearer to them that this is automatic, but we'll still have to see. So what I want to say to tenants anyway is this change doesn't mean that like tomorrow, all those cases are necessarily going to disappear. They ought to disappear, but are tenants going to have to take some action to make sure that happens? We'll have to see how that plays out. Okay, next slide. Okay, this was a law that I worked on separately from Homeline over the last few years that was passed last year. It created a right to appointment of free attorneys to tenants in public housing that are facing evictions claiming a breach of the lease. There was some confusion that, again, I didn't really think was justified, that this might apply to other types of subsidized housing. Public housing really is a term of art. And, but anyway, so there was some confusion out there. So the change here is to reference a couple of different laws. One that is the law that created public housing, that's that Housing Act of 1937. There's a variant in public housing called the Rental Assistance Demonstration Program, and that is the second reference to a law here, the Consolidated and Further Continuing Appropriations Act. You got to love names like that. And so this now applies to tenants in both of those housing programs, public housing and the RAD program, who are facing evictions for breach of lease. It does not cover non-payment of rent. Okay, next slide. Okay, there was a big change to the statute that governs how eviction complaints are delivered to defendants. Most eviction defendants are tenants, but there can be that sometimes are homeowners in disputes with mortgage finance companies over foreclosure. It basically replaces 504B 331 with a new law. And so when you look at all this underlying text, you might be thinking, this is a really huge change. It is a change in some, I'd say, nuances about how eviction complaints are served. I think it's more from a clarification than from a really, it looks like this is a massive overhaul. Unlike the utilities that we discussed earlier, which was a massive overhaul, I would say that this is less of that. What it does is it does add some language regarding when landlords have to use electronic communication in addition to having someone deliver the court papers to the tenant. And it also adds a deadline for the plaintiff, which again, most often is a landlord, filing the affidavits of how they accomplish delivery of the court papers on the tenant, that they have a deadline for doing that. That deadline is the same deadline that landlords in Hennepin and Ramsey County already have under those housing court rules. So let's walk through these next slides. There's a definition here of plaintiff, and we'll go on to the next slide. So this begins the discussion of how plaintiffs in eviction cases are supposed to deliver court papers to the tenant. Again, 7 days is the standard that we have right now. This does add that if the plaintiff regularly uses electronic communication, so that would be text messaging, email, all the different variations on that, that the plaintiff must make a good faith effort to communicate to the defendant that an eviction hearing has been scheduled at least 7 days before the date of that hearing. And so we think that this will be to the benefit of tenants that for whatever reason may not, let's say, for instance, the tenant is in the hospital and comes back from the hospital right now and would find that there were some court papers that were dropped off maybe 5 days ago for a court hearing that's coming up in 3 or 4 days. This would require the landlord, if the landlord and the tenant have been communicating, for instance, by text, that the landlord communicate that as well. So then the tenant would know, hopefully, 7 or 8 days out ahead of this hearing, rather than just finding the court papers when he or she got home. So this is, I think that's one of the bigger changes that is in this section of service of the complaint. Next slide. What I see here is pretty similar to what we have right now. It's worded, I think perhaps in a little more comprehensive way, but this really doesn't change how a landlord would do personal or substitute service. The change here related to filing the affidavit is at the bottom of this slide. Next slide. And again, this does not make any significant change in service by mail and posting. As you can see, the 7-day deadline shows up here in the last slide. In the existing law, I always believe that the 7-day deadline for service applied to all these. This makes it a little more clear. But the substance of this is really similar to what we have right now. Next slide. Again, not really anything new here. The service has, in my view, always had to be at the defendant's individual unit rather than some other place in the building. Again, the only change, I guess, of some significance is applying the 3-day rule for filing of affidavits. This will now apply statewide rather than just in Hennepin and Ramsey County. Next slide. And this, in my view, what is added here again, as you see it in a few of these slides, is the landlord doesn't have to use electronic communication if that's not something that they have been using. So that's kind of like the flip side of what I mentioned earlier. The effective date here is January 1, 2025. Okay, next slide. Eviction action judgments. This was a clarification that a tenant, there was a change last year that said that the court shall put hold on an eviction for a reasonable period not to exceed 7 days. That delay doesn't happen in cases involving illegal drugs, prostitution, firearms, or significant nuisance activity. But I think there was an error in the law last year that said that this delay didn't apply to non-payment rent cases, and that was not the intention of the advocates for that. These laws were advocated for the Legal Services Advocacy Project. And so this makes it clear that this kind of short delay at the end of an eviction case applies to that crossing out of 504B291 means it applies to non-payment rent cases. Okay, next slide. And I think we're back to Rachel.
Me. My turn. Thank you very much, Larry, for all of that. I know it was a marathon there. We are coming to the end, folks. So well done, everyone who's stayed with us thus far. Expediting rental assistance. This is another one of those laws that went into effect that is not actually in 504B, but it does impact tenants and landlords. So 462A.2096. These are a listing of requirements that the Minnesota Housing and Finance Agency has to implement to get emergency rental assistance applications processed faster, and the timelines for which they need to have adopted those changes by. So there is a lot of stuff in there that is basically just very specifically about what MHFA has to do and things they have to take into consideration for processing these emergency applications, but it is not necessarily all going to, as Larry said, it's not going to all happen tomorrow. It kind of going through timelines for the next few years about how to get these programs administered faster, and looking for recommendations and things like that. This is effective on 8/1, but again, not going to be necessarily effective. We won't see necessarily changes to the emergency rental assistance programs on 8/1. However, Michael wanted to chat real quick about this one.
Yep. So there was a coalition effort to try to get more money for emergency rental assistance that was accomplished in getting additional appropriation of $8 million for the Family Homeless Prevention and Assistance Program. Emergency rental assistance is an eligible use of these funds, and it's always used as a major rationale for us increasing the getting the increase of one-time funds for this purpose. Also, emergency rental assistance is one of the most effective ways to prevent evictions, and so it's one of the reasons why Homeline was so supportive of it. We are so glad that this actually happened, that the additional money came in. We actually asked for 200 million in one-time funding because the need is so great. Obviously, that was not something we could accomplish this year, but it's where we ended up with things, and it is going to help additional households stay in their home.
Yeah, to give a little bit of a preview for next month's webinar, there were over 25,000 evictions filed last year, according to our statistics. So this is clearly something. Most of those were non-payment of rent cases, and so obviously this is something that is can have a very large impact going forward. All right, so stick with me, Michael,
Yeah, here.
because so we want to also, looking back and moving forward, this is something that again you had wanted to, I think, close us out with.
Yeah, actually, let's stay at the moving back slide for just a second here. I want to make sure, first of all, to just give some thanks to legislators and constituents and groups that got things accomplished this year. We need to thank our chief authors from many of these pieces of legislation. So Senator Mohammed and Representative Agbaje did a tremendous job in working on many of these proposals. There's other ones where they weren't the chief author on, and I'm sorry, I'm not going to be able to thank everybody, but I want to say that I worked a lot of work with them and was very appreciative of the efforts that they put in to get many of these pieces of legislation into law. Also, we had Senator Port, Chair Port, and Representative Howard, or Chair Howard. They were chair of the committees, of the housing committees, that helped us get hearings and have these issues be listened to by legislators and passed into law. Again, a special shout out to Representative Herr for working with us on the mitigation of damages, and then Senator Verbaeten for playing a huge role in the effort that we're trying, and we did try to get more, to get the tenant, the source of income protections or source of income discrimination that currently is taking place. She was a huge champion of trying to reverse that, as was the Lieutenant Governor Peggy Flanagan working on that. And then also Representative Hassan was in on some of the legislation that we worked for. So I want to thank them. I want to thank anybody who made calls to their legislators. I want to thank that specific constituent that called Representative Herr, and encourage others, if you have concerns, to do the same thing as she had done before. Okay, now moving on to the other slide. There was and is huge power imbalance between tenants and landlords. And a few months ago, we had used this slide to say that, well, there had been 20 years ago, leases were most often in the 4 pages range or less, that they actually have increased dramatically in size, from 30, 40, 50, even 60 plus pages of text that tenants have to look over, that regulate their housing. And it's done through private contract that happens. Well, we need state law to balance out what has been an increase in the regulation that has happened of tenants through the leases, which are written by landlords. And so that's why all of these huge successes we've had the past couple of years were so necessary, and why additional ones are necessary as well. And so moving to the next slide. We have this sample 52-page lease, and the pink segments are where the landlord has things that they have as sort of protections or demands that they make of tenants, or protections that are made for landlords. And the green section is tenants, where they have the protections or the rights that are in the lease. I believe the difference was that there was, I'm forgetting the percentage, but you can see here on this slide just a dramatic amount of power that landlords had. And so we've begun to address these issues through the state law that we've done for the past couple of years. Before we move on to questions, actually, Rachel, where do you want to do do you want to do some questions first, or should I take it away a little bit more?
Why don't you take it away a bit more?
Okay. So hopefully we'll have some time for some questions, but I did want to conclude the webinar by first taking this opportunity to ask for your support. While this webinar series was supported by a grant from the Family Housing Fund, Homeline's other tenant-focused programs benefit from direct donations from clients and other individuals. We are in great need right now of additional support to maintain capacity for our programs, as well as quick service response time to our hotline. Last year, we advised over 20,000 households, which is first time in our 32-year history that we've hit that benchmark. We organized tenants throughout the metro area while overseeing a cohort of AmeriCorps Vista tenant organizers. We fielded a record number of inquiries about evictions. As Rachel said, there were over 25,000 filings this last year, the largest we've ever seen. And we successfully advocated for changes in law at this past biennium to get tenant protections, massive changes there. We can only do this work if we have a strong network of supporters. And so we want to make as big a difference as possible. And we'd ask that you consider making a donation with your dollars or your time. We have volunteer opportunities as well. And so there's a link that's shared with you. And we'd ask that if you would consider a donation, again, of your money or your time, we would greatly appreciate it. I'll turn things over.
Fabulous. Thank you so much for that. I put the links there in our website, in the chat for the donation and the volunteer opportunity links. So we did get a couple of questions. I know I answered some, and I think Larry answered some as we were going through. The pre-submitted questions, there was only one that was specifically about this last session, and that was about what happened with the pre-lease deposit stuff, if anything. And Michael, if you want to cover that really briefly, we've got about 4 minutes, so.
I'm just going to say that we had proposed that there be changes to pre-lease deposit, and that it not be required, but it didn't move forward long enough, or it didn't pass the finish line. And so we'll be coming back in future years to do something with that.
Yep. All right, so a couple of questions that had come through. So Jessica, you were asking, is there a time limit of statute of limitations and having the Attorney General investigate violations? That is a great question. I don't know the answer to that. I actually posed it to some of the other attorneys here at Homeline while we were talking, and no one had a idea if there was a limitation specifically for Attorney General investigations. Anyone on this call know?
Yeah, well, I don't know that there is a statute of limitations on investigations. There are statute of limitations on the filing of court
Sure.
cases. And so that might be the more relevant one. The general statute of limitation for contract claims and tenants and landlords and leases are a form of a contract is 6 years. But there also are different statute of limitations when there are laws creating penalties for conduct. So it's possible, and my recollection is that might be a 2-year statute of limitation. So that would be kind of those would be kind of the paradigms for figuring that stuff out.
Yeah. Okay. Quickly here. Anonymous was asking specifically about the ask versus require for the early renewal. The statute language does say require, though I would caution that asking for renewal prior to that 6-month time frame limitation would be problematic. But the statute language does say require. Let's see here. We got 2 more minutes. So let's see here. Anonymous way back at the beginning was asking about what remedies the housing court could provide in a rent escrow action for violations of discrimination laws. We can
Well,
get it.
well, the current the current remedies in rent escrow laws were built around repair problems and habitability issues, but they also included lease violations as well. So one would be to order the landlord to stop the violation. So if the discrimination is the violation, to stop that. The court could award rent abatement or a rent refund for the time period in which discrimination occurred. A little bit unclear as to whether the court could add in law remedies under discrimination laws or not.
All right. And let's see, Anonymous was talking about closed cases opposed to dismissed cases. That's something I think that as a whole we need to, kind of look at as a what that means. So I think that's a larger conversation than what we have time for today, obviously. Jessica, if you, we will get back to you on that if that's something that you would really like to know the actual number. And then Anonymous also said most of our landlords do not file affidavit of service 3 days prior to court. Then hopefully that it's something that we'll be more explicitly able to deal with after these new laws are really specifically hammering home.
Yeah, what I would say about that is now statewide, that's something you're going to need to do. It's
Yep.
not going to be limited to Hennepin and Ramsey County anymore.
Yep. So, and if you're seeing that, it's not being done, call it out. Awesome. Thank you everyone so much. We are exactly at 3 o'clock. I want to thank Michael and Larry so much for all of their expertise, and thank you all for joining us today. Again, this recording is going to be up on our website, homelinemn.org, in the next few days, along with the PDF versions of these slides. Have a great rest of your day and take care now. Thanks all. Bye.